Now we're in Chapter 8, Section 2. We're going to discuss the U.S. Court of Appeals, analyze how the courts make a decision, and examine some of the roles of the judicial branch. So let's just look at some of these. You have district courts or federal courts where trials are held and lawsuits are begun. It's just a term that means this is a district court. This is going to be the court where is over this entire district. They have original jurisdiction, which is the authority to hear cases for the first time. You're not going to sue someone and then go to the Supreme Court the next day. And again, unless it's about constitutional issues, you're not going to the Supreme Court at all. But they have original jurisdiction because that's the first case that you hear it in. District courts are the only courts to have witnesses and juries that hear the cases and rate verdicts. When you get to appeals courts and higher courts, they're going to be going based on what these earlier courts said, so there's no point in having a jury or witnesses. You pretty much look at what has been said already. They'll have a piece of paper. You'll have stuff that the witnesses said. They'll have videos, I guess, that you'll watch and things like that. And you can use that as evidence, but for the most part, you're not going to call witnesses in. You're not going to have juries and things like that. The next court that people go to if they lose their case is the U.S. Court of Appeals. And the U.S. Appeals Court, or the Appeals Court, this is the court that reviews decisions made in the lower courts. They look at the case to determine if there was a wrong verdict in the first case. So say, for example, if you sue somebody and you know without a shadow of a doubt that that person was wrong, but the court case for some reason rules in their favor. If you're willing to continue to pay money, court costs, legal fees, all that kind of stuff, then you can fight it in an appeals court where they'll look at the evidence from the case, they'll look at what the witnesses said, they'll look at all the different information, and then they'll decide whether or not that there was a mistake or they will uphold the decision. Appellate jurisdiction is the authority of a court to hear a case appealed from a lower court. So the idea of appellate jurisdiction is what gives the court jurisdiction to hear an appealed court case. So when a court has appellate jurisdiction, they are a court of appeals. They are a court that hears when you appeal your previous case. People will appeal the court ruling if they feel they were cheated or the judge made a wrong decision. Sometimes they'll say they feel like that the judge didn't hear all the evidence, or maybe the judge had an issue with them. Maybe they got frustrated and lashed out at the judge, and they felt the judge is doing this out of revenge or whatever. Whether or not they believe that or not, then it goes to the appeals court, and the appeals court decides whether or not there was enough evidence to see this or not. Basically, what I like to relate this to, if you like football, is kind of when they go back and do like a review. Say, for example, that a coach challenges a call on the field or whatever. Say there was they said this person was down at the 9-yard line. You had to get to the 10-yard line or the 8-yard line in order to get a first down. And the coach feels like that they did, but the ruling was that they was down at the 9-yard line, and the coach challenges that. That's like going to the Court of Appeals. You challenge it to say, no, I believe that we were a yard ahead of that. And then if they don't find what they call, what do they call it? And I'm drawing a blank. It's like irrefutable proof that it doesn't need to be overturned, and they'll leave it the same, or they'll overturn it and rule with the challenge if the person is right. And that's what the Court of Appeals does. A circuit is a particular geographic area. So a circuit court would be a court over a certain jurisdiction or a certain area. The Court of Appeals for the federal circuit has nationwide jurisdiction. So for the federal circuit, the Court of Appeals can see any case from anywhere. Now, if something is remanded, it sends the case back to a lower court to be tried again. So if they remand, they say, okay, well, let's go back and take it back and try this case to be, again, just kind of reset. A panel of 3 or more judges meet, review the case being appealed, and listen to the lawyers from each side. They do not decide the guilt or innocent. They just rule if the defendant's rights have been protected and receive a fair trial. If they feel like there was not a fair trial, if they feel like that the ruling was incorrect, then they can change that. An opinion, and you need to really get this because you'll hear a lot about this in this chapter. An opinion is a detailed explanation of the legal thinking behind the court's decision. So when the court gives their opinion, it's not, well, my opinion is that person's terrible. It's our opinion is that based on the evidence, we have found that that person is guilty of committing this crime. That's an opinion. They also do. There's different types of opinions. There's opinions where they disagree with the majority opinion. There's opinions where they agree on the same outcome but for different reasons. And so there's a few different opinions that are written off of a court case, especially something like the Supreme Court, which is going to hear big controversial issues. Precedent, which you should know this because we talked about already, is ruling based on a previous case. So they'll say, by using precedent, in the case of so-and-so versus so-and-so, the judge ruled this way, and we feel like that this is the same type of situation, so the judge needs to rule that way in this case as well. It's a ruling based on a previous case. It is not binding in law, but it is a very good idea of how the court's going to rule if it is an identical case. It does not have the force of law, but it's a very powerful argument in court. The chief decision makers in the judicial branch are the federal judges. Some district courts have more judges because they have a larger population. It's based on population count. Each appeals court has from 6 to 27 judges. The Supreme Court has 9 justices. And so the appeals courts, you can range from 6 to 27 judges. The U.S. Supreme Court has 9. According to the U.S. Constitution, the President appoints judges and the Senate approves. So in this case, the President will say, I'm appointing so-and-so as a federal judge, and the Senate has to do confirmation hearings and make sure that they agree, and then they approve that nominee. This really gets controversial when it comes to a Supreme Court nominee. Federal judges, not so much. Supreme Court, very, very intense. Presidents want to appoint judges that share their ideas and beliefs. Even though judges are supposed to be bipartisan, they usually rule in a way that is a little bit partisan. The president usually follows a practice called senatorial courtesy, where judges' appointees' names are revealed to their home state senators first. So, say, for example, he was going to appoint a judge from the state of Alabama. President Biden was going to appoint a judge from the state of Alabama. He would call up Richard Shelby and Tommy Tuberville and say, hey, look, I'm going to appoint this dude or this woman as a judge. What do you think? They may say, we don't like it. We don't want you to do it. The president doesn't have to stick with that. They don't have to say, oh, okay, you don't like it. I'll change my mind. But sometimes they do. Sometimes they say, oh, well, if you don't think it'll be a good one, then I'll pick someone else. If both senators reject, the president will usually remove the name from consideration. They don't have to, but a lot of times they will, just because it's not a good political move to go against the senators from the state of a judge that you're trying to pick. Once appointed, federal judges may have their jobs for life. That's the reason why it's a big deal, because once they get it, they're in there until they die or retire. Federal judges know their jobs are safe, even if they make unpopular decisions. That's what makes them not political. It's the only non-political branch of our government, because you're not going to get voted out. You're not going to have an election in 4 years or 6 years or 2 years to determine whether or not you need to stay in office. They're just in there for life, no matter what decisions they make. Judges have help from clerks, secretaries, court reporters, probate officers, and more. Each district court has magistrate judges that take care of much of the judge's routine work. And every federal district of the United States has a U.S. attorney and one or more deputies. These are just other court people that help out. They help determine information about the case, keep security during the case, write down information, keep up with the notes, give opinions about stuff, whatever it is, whatever the court needs help with, that's what these people are there for. It is the U.S. Attorney's job to represent the United States in civil cases in which the government is involved. You have the U.S. attorneys, which are attorneys for the United States. Each federal judicial district also has a United States Marshal, which is another high-ranking official that oversees all these districts, oversees the district. A subpoena is a court order requiring someone to appear in court. If you are subpoenaed, you have to report to court under threat of legal action being taken to you. So if someone subpoenas you to court, then you are required to show up. You can't say, I don't want to show up, but they can, maybe. Yeah, they can. And that brings us to the end of section 2. And so we will continue this in section 3.